Accordingly, WPCT 18 of 2026 is partially allowed on contest, thereby setting aside the influence judgment dated February than such passed by the CAT and affirming the order of dismissal of the respondent dated such and such passed by the Chief Secretary. This is the appellate order. No rest to cause for discharge certificate. Partially allowed because the tribunal has also held regarding the other aspect of it.
My lord. My lord.
Item number 2. Accordingly, MAT 70 of 2026 is disposed of by modifying the impugned judgment dated February 19, 2026, passed in WPA 547 of 2024 by passing the following direction. The appellants through the Department of Personnel and Training, Ministry of Personnel, represented in the present appeal by its secretary, being appellant number 2, shall within 90 days from date accord approval to the scheme of 2023 as notified by the respondent 3 in August 2023 by reading up the said scheme to the extent that immediately after subclause C of clause 2, the following proviso shall be inserted. Provided that the term illegal appointment in subclause B above shall include employees 1. Who possess the prescribed minimum qualifications. 2. Whose appointment shall be against sanctioned posts or sanctioned functions. 3. Whose engagement as DRM, daily rated Mazdoor, has been for a substantial length of time in work of a perennial nature. And 4. The nature of work performed by whom is integral and essential to the functioning of the employer. We have expanded this irregular. Irregular is already there. We have expanded this that to include these also. And in any event, you have said the other riders are there. 10 years and all those are there. So, because we have wanted to restrict that sanctioned post or any other post. So, since irregular is there, we put this under irregular so that this can also come within the other sanctioned post, not beyond this. And for the sake of clarity, the revised clause 2 of the 2023 scheme shall read as follows. We have set out clause 3 incorporating clause 2 incorporating this. Thank you so much. Can 2 is disposed of consequentially. There was a can 1 also, section 5. None moved it. We have dealt with that also. Some days delay we have. Yes, as rightly pointed out, that sanction posts and these 3 cover all those. Yes, sir. We have dealt in the line of Jaggo and those 3 judges. We have given you 90 days deliberately because 90 days is a period of appeal. No. This is district court. Yes. Right. We'll send it. Yes. Similar order. Yes. As per the judgment, as per our judgment of the larger bench of this court, comma, the district judge, comma, Andaman and Nicobar Islands has jurisdiction to hear all appeals from original decrees / orders. Accordingly, FMAT 7 of 2025 along with IA number CAN 1 of 2025 are dismissed as not maintainable on the ground of jurisdiction, granting liberty to the appellant to prefer an appeal against the self-same order. This is an order before the concerned district court. First up, the learned advocate on record for the appellant shall be at liberty to withdraw the certified copy of the impugned order upon furnishing photocopy thereof for the purpose for the records. First up, no address to costs. Interim order if any stands ready. You are Mr. Sonkar. Yes. Yes, Mr. Sonkar. What is the matter?
Bail order was passed on the Friday.
The other side is not there. You have served a notice?
Yes, I have served. I have served in advance yesterday.
Yes.
My lord, the bail order was passed on Friday, and the bail bonds were furnished on Friday itself, and the release order was transmitted to the jail authorities on Friday itself. Thereafter, the jail authorities claimed that there is a production warrant pending from another court in my brother in a particular case, because of which we cannot release him from the jail, because we have to produce him before that court on 29th of June. My lord, I produced before them the bail order in that case also, which was granted by the Honorable High Court, and I requested them to verify the records as the bail bonds were submitted in that matter also. Thereafter, my lord, on the strength, I would beg my lords to just peruse the DNSS 2023 value.
DNSS, DNSS.
Oh, my lord, submits your lordship.
Yeah, he released yesterday, my lord, but the detention was illegal. Yesterday, after the filing of this,
Become infectious.
my prayer goes
But
that
every time if they have to file a habeas corpus for release, then Ms. Zinu, please take care.
it is my lord.
Please sensitize your officers. Sensitize your officers, because every time if they have to come up in habeas corpus, we are thinking of directing you to pay the costs, the state. The next time we'll think. This time we are. So whatever we said, just convey it to him.
No, yes, left for Kolkata, your lordship, because his policy. It is killed. That's the reason why I don't know about anything about this particular case. But anyhow, I will convey it.
DNSS, my lord.
So you have been released yesterday, so we'll record it.
Yes, evening.
Learned counsel for the despite service, comma, should we record your appearance, Ms. Zinu?
Yes.
Very good. Despite service, learned counsel for the petitioner submits that despite having obtained bail in a proceeding in a criminal trial, comma, the petitioner was not being released by the state, subsequently, comma, on the pretext of a production order in a different case, comma, the respondent authorities kept on detaining the petitioner, comma, upon which the petitioner produced a bail order obtained by the petitioner in the other proceeding as well. Next paragraph. However, comma, it is candidly submitted that the petitioner was released yesterday. Next paragraph. Although the habeas corpus petition has become otherwise infructuous, comma, we want to note a word of caution for the respondent authorities to the effect that on every occasion when a petitioner when an accused obtains bail, comma, he/she cannot be compelled to come to court by filing a habeas corpus petition. Accordingly, it is expected that the respondent authorities shall sensitize their officers in that regard. Next paragraph, be that as it may, comma, in view of the present application having been rendered infructuous due to the release of the petitioner, comma, WPA within bracket H number 1 of 2026 is disposed of in the light of the above observations. No rest of us. Urgent secretary. Thank you. Ms. Zinu, please ensure that this is circulated, this last, to the officers.
Definitely.
Because it's not, state does not do anything, the officers do. So, thank you.
Item by
Sorry.
Get another public this time it's for what of
We were expecting something of this sort. So we did not look into the document, but
we have to still we have to keep something back to the society.
Mr. Tapris, we were noticing certain water processing plants. They are there, not that they are entirely not there. Anyway, you have given notice to the other side?
I've given notice. I don't think so anything technically can be done today.
Yes, obviously.
But just to put my own stake, some reports or something can be called upon.
Yes, if there is a prima facie case, Mr. Tapris, just satisfy us on the fact.
Certain documents, right to information.
Right.
This is a letter dated 23rd of April 2027. We kindly turn over to the next page.
Yes.
Page 82, column number 13.
Right.
Present water storage for the next number of days is 52 days. As on that. This is 52 days is being calculated at the rate of we are getting supply once in 4 days. So actually the water which is available is for the next 11 days, my lord. So only for the next 11 days. Now this scenario, my lord, in these islands, it's not started now. It started during the early 2000s. The first public investigation regard was filed by the state by members of the park. In 2007, if my lord may kindly see, I was not able to collect copies of all the orders and the whole file. My lord, you see, it started page number. The first order would be at page number 17.
Mr. Tapazunu, one request in the affidavit portion, please also disclose the occupation of the.
Social work. That's it. So,
No,
oh, in the affidavit.
in the affidavit portion, just indicate your capacity,
Indicating that-
your occupation, not social
Definitely,
work.
he has,
Otherwise, because there may be certain implications, not in a public interest litigation, only in other matters also.
has to be public.
Yes, we know that. No, but occupation for other reasons, but in other matters also, we are noticing that in some cases it is not there. Occupation may be necessary regarding other cases. Yes. So page 82 you have seen, and there are previous directions also.
Previous directions.
Show us one direction, Mr. Tapis, just for.
But technically, I would show, my lord, that the roads public interest litigation, which was filed in 2007 and subsequently in 2010, thereafter, an affidavit, my lord, was filed by the respondent authority. My lord, would kindly come to page 57. The 11th would be 858, paragraph 9.
Yes.
That the statements made in para 5 to said application are admitted to the extent borrowed of record and the rest are disputed and to submit that many projects are under active consideration and are to be implemented by the public works department.
Yes. Yes.
These projects will provide additional water in the very near future. The PVLC also proposes to set up 7 MLD desalination plant for which approval of the administration has been received on 30th of June 2010. We are in 2016 manner, and this project has not seen the day of the light. And we have been, I'm not getting it personal, Melon. I'm not reading it also here. Many officers were sent to foreign countries like Singapore and Spain to assess the workability of these projects. Sanction was done, an undertaking was made, an affidavit was filed before Sovereign Court. We are running scarce of water manner. So why these projects have not been implemented? Well, at this stage, it's none is availing, Melon, but I would request. So this thing I can understand, Melon, I'm concerned of the fact that it can't happen overnight.
We are not directing a report, we are directing an affidavit in opposition so that they can discuss everything.
One more very important thing what we have been seeing, madam, here is that pursuant to the judgment of the before the LC matter was Union of India in 1996, which particularly relates to the controlling of the groundwaters, my lord. We have been witnessing that the notification was issued by the Secretary of the Environment Protection Act, my lord, constituting the Central Groundwater Authority and subsequently the goals in the state levels. Now we have the Central Groundwater Authority board and for the eastern regions that Salt Lake, Calcutta, which covers even the Andaman Nicobar Island. So we see indiscriminate commercial borings happening in these islands, my lord, which is reducing. I have also seen the technical aspect of what would happen if this is not controlled, my lord. The groundwater level would go down. This would result in the erosion of the soil, my lord, the fertility of the soil would be lost, and there would be ingression of the seawater into the subsoil, my lord. So the central ground board also needs to find report as to what method or methodology they have adopted to monitor, because every ground, not for domestic purpose, but commercial fellow, they have to either they have to pay some fees to the government. It has to be in a controlled mechanism. The diameters of these bore wells are restricted, fellow. If it's for domestic purpose, it can't be more than 4 inches of diameter. For commercials also, there are various restrictions, my lord. So let all of them come with an affidavit, my lord, and particularly the authorities, what they are contemplating these projects to address this issue, which is going on for about 25 years, my lord.
Learned Counsel appealing for the petitioner points out that the petitioner is a social worker and the present public interest litigation has been filed to address the issue of water crisis in the Andaman and Nicobar Islands. Which of next para, Learned Counsel takes the court through the annexures to the application, from which it transpires that the PBMC, comma, in its affidavit filed as long back as in August 2020, comma, in a similar matter, comma, had stated
2010, man.
oh sorry 2010, not 2020, 2010, comma, had proposed to set up a 7 MLD desalination plant for which approval of the administration was allegedly received on June 30, 2010. Which have learned
Their own statement, not any.
allegedly means that they might have received it earlier also. They don't.
For the dates.
They for the dates. Therefore, allegedly qualifies the last one. Allegedly on June 30, 2020. Question. Received it or allegedly? You're right. Received allegedly on June 30, 2010. Question. Next part, it is further pointed out that there has been a plethora of litigation to address the issue, but till date, comma, no effective steps have been taken for addressing the issue of water supply to the islands. Question. Learned Council also places reliance on communication by the concerned department, comma, with regard to an information sought under the Right to Information Act, comma, dated April 23, 2026, from which it transpires that the present water storage on that date, comma, for the next for the upcoming period, comma, was 52 days. Question. It is further argued that there has been indiscriminate boring for commercial purposes on the islands, comma, which not only brings down the groundwater levels, but is also attended with the risk of drawing seawater underground, comma, which may have serious ramifications. Which the next para. Thus, comma, it is submitted that appropriate steps should be directed to be taken by the respondent authorities with regard to the above issues and the general problem of scarcity of water in the islands. So next para, in view of the amendments made in the application as well as the annexures thereto, comma, the court is paradoxically satisfied that the issue raised therein relates to public interest. So accordingly, the respondents are directed to file their affidavit with bracket S in opposition to the application, comma, with particular regard to the reliefs sought therein, and disclosing the exact steps being taken by the respondent authorities and measures which have already been taken for the purpose of addressing the issues raised in the present public interest litigation. So such affidavits shall be filed within 3 weeks from date. So reply within bracket S bracket close, if any, thereto shall be filed within a fortnight thereafter. To have liberty to the parties to mention the matter for enlistment before the next available circuit after the timeline for exchange of affidavits is over.
Moving the
Yes. Mr. Kumar, you are there in the previous application, so do you have
one of the petitioner in those. I was practicing at in 2007, Mr. Balan was the petitioner.
So after that, you are inducted into this panel.
And 2010, Mr. Kumar.
Well, First line add something. Despite service, none appears for the respondents at the time of call. This should be the very first.
Very first.
Taken.
One,
Yes, Mr. Tabriz.
the problem municipal.
Sorry. Yes.
The problem municipal council and within the intervening period, directed measure to supply potable drinking water to the residents through tankers wherever it is not possible to do so by pipeline.
So that means we won't specify the modality
Modality.
at this stage. So
Kind of, but indicate something well.
at this stage.
The situation is obvious, which should be.
Yes, we know. Yes.
Because was regarding that land acquisition matter.
IPZ, yes.
It has been filed, it has been numbered. As instead if it goes in orchard, but I just want it to be tagged along with that appeal, the orchard has already passed it order, that way we have been directed to check.
When the appeal is taken up, whichever bench takes up, then fine. Otherwise, it will be misplaced. Thank you. We'll sit singly. I'll sit after 10-15 minutes and 10 minutes, not 15 minutes. Her leadership will sit immediately.
Any mentioning? Item number on. WCF 125 with W25.
Yeah, when is the interim order expiring? When? We are extending for a limited period. The interim order granted on March 18, 2026 is extended till August 15, 2026 or until further order, comma, whichever is earlier. So let the matter be listed in the next slide.
Time to file the reply to
Opposition they have filed already. Sir, the time for filing reply is extended for a period of a fortnight from date.
Item number 3. Except 10 of 2026.
Now, responded. When does the interim order expire? देखिए फाइल करता हूँ.
There is no stay order.
It is mentioned for extension of interim order.
There is no interim order. But it is matter. Earlier they have made for an application, but they have not pressed it. At the time that the second appeal was accepted. And yesterday I received the application from their side. Again, they have made a can application for the state.
Yes,
First of all, it is not an extension of interim order.
no.
It is an application where I am seeking for an interim order.
If it was not granted at the inception, why should it be granted now, Mr.
My lord, at the inception, I have not pressed this application at that point.
Why?
My lord, at that point, my lord, I will show only 2 pages of both the orders, my lord.
No, but you have not placed without any leave. I mean, why should you grant it now?
Lord, you can't see the February 23rd order. My lord, there all along exists a status quo order, my lord, during the trial. I will show from 2 parts of the order of the trial.
What is the changed circumstance, Mr.
My lord,
When the appeal was admitted, there was
in application, it was not stated, my lord, only because the documents are also.
the appeal has been directed to be prepared. Finally made ready for hearing.
Yes.
So, are the paper books filed?
No, not fine.
You are to file the paper book.
Yes, my lord.
File the paper book and will direct the appeal to be listed in the next second. You have filed another can. This can 1 is that? No, can 2. Can 2 of 2026 is an application for interim stay. Interim stay. Which of next parallel counsel for the respondent submits that on an earlier occasion, comma, a similar application for stay was not pressed by the appellant. Which of next para, accordingly, comma, the court does not find any change of circumstances necessitating imposition of any interim order at this stage, comma, since a similar prayer was not pressed by the appellant at the earlier stages. Question of next para. In any event, comma, since the appeal has been directed to be made ready for hearing, comma, we direct the appellant to file the paper books at the earliest. Question of next para. The appeal be listed in the next circuit before the appropriate bench for hearing. Can 2 of 2026 is accordingly disposed of without any orders to costs. Thank you.
Item number 4. PLF 5 of 2026.
My senior please.
This is the order passed by this Honorable High Court, granting bail to one of the co-accused.
Your senior is? Pardon?
Zinu.
Ms. Zinu. Mr. Elangu, we are passing it short passover.
This was the order that passed just 3 days before on the ground of non-communication of grounds of arrest. 94 witnesses, only one.
Mr. Elangu, just let her come. We will.
Co-accused already.
Ma'am, we are passing it over for a limited period. Whenever she comes, just mention it in between matters so that we can.
Item number 5.
Already you have made extensive argument. This
It requires, IPZ requires.
that
We'll give you liberty to file that up.
I know what happened. I saw only 2 provision of the said regulation, if my lord, it comes to my lord, because my client, my lord, comes to page 41 of the writ petition, and thereafter this.
Yes.
Serial number 9, my lord.
9, yes.
It says distance from water body. It says more than 200 meters from potable source of water. However, during monsoon, a nala flows adjacent to the crusher, the water of which is not used for drinking purpose. So, my lord, I have got the map also that a nala flows adjacent to the said crusher. Now, my lord, can you see page 3 of the CRZ, which my learned friend relied yesterday? My lord?
Yes.
Roman 3, my lord. Roman 3, subclause 1, if my lord sees the land
Yes.
area from high tide line to 500 meter on the landward side along with the seafront. My lord, I say this is not applicable in my case. In my case, serial number 2 is applicable. It says ICRZ shall apply to the land area HTL to 100 meter of width of the creek, whichever is less on the landward side, along with the tidal influence water bodies that are connected to the sea, and the distance upon which the development along with such tidal influence water is to be regulated shall be governed at the
So
distance.
you say the Nala is such a.
Yes, my lord. A Nala is there, my lord. I have the map also. I have shown Mr. Rakesh also because I don't want that I should make a fresh argument which is not there. I have informed and I have placed the. I have shown the Nala photograph, everything.
So on the ground of Nala, they have nullified your.
My lord,
Literally
see,
nullified it.
clause 9, if my lord sees now, it says more than 200 meter from potable source. So, my lord, if within 100 meter, then definitely CRZ,
So
ICRZ.
this 200 rider is not correct. You are saying 200 meter is not the right.
No, 200 meter is correct, my lord. It says HTL to 100 meter, ICRZ is applicable. My land
Oh,
is
it's not applicable at all.
not applicable. Now, my lord, can you see page 41, the report which earlier my learned friend has relied upon? At page 41, my lord will find that my learned friend has second paragraph.
Yes.
As per record, the subject land is located 165 meter away from high tide line. However, the approach road towards sea, the high tide line is at a distance of 210 meter. As per map, a road is bifurcating the crusher unit and the sea. So, my lord, therefore, this will come into play.
Yes, what do you say to that?
And based on the methodology directing the forest authorities to verify whether the case of the applicant is comes under the clause 3.
He has not yet applied even for this.
Because as per my report, it says I require it. It comes.
No, but Mr. Kumar, the other Mr. Kumar's submission is that it does not come within the under the ICRZ at all.
It cannot be because the report is clearly said high tide line. It may not be said there are 3 aspects in the report. The high tide line is below 500. If it says that there is a Nala 100 meter width.
No, the language of Roman 2, please come to the language of Roman 2, Mr.
Explanation.
Rakesh Kumar. So we could have construed this as you were saying to be in addition to that, but this 100 meters is less than 500 meters. Therefore, those two cannot operate together. Am I clear to you? I mean, yes, either it has to be one or A1 or 2. Both cannot apply 100 and 500.
An explanation is given by the same paragraph. And says the authorities based on the longitude and latitude of the map. If you are see page 43.
So this stone crusher is otherwise 500 meters away from the seafront.
Less than 500. That is why they given the
appointment.
That's why rightly they have given this license to all others. Only for me, this law management system was operated from 2018. Can you see 43? That's why they have been said. If they could have been said that as an enablement, they could have not said for come under the 40. Can you come to page 43?
43, yes.
They have specified note the longitude and latitude of the approved map of prepared based on IPZ 2021 that is enclosed as completed. But as such, based on this, the report was furnished to the permission. Based on that, they have been said to obtain CRZ clearance.
No, Mr. Hindu Kumar, why do you say that either of the two both should not apply? And because why I'm saying this, because two operates in a different footing, on a different footing. It's with regard to this with the creek. In regards to creek, we are equating with Nala. So this speaks about a creek. But if suppose it is beyond 100 meters from a creek, but otherwise it is within 500 meters from the high tide line, then why shouldn't one apply independently of
My lord, you see clause 9 of page 40.
yes. 200 meters is neither here nor there.
No. It says more than 200 from potable source of water. However, during monsoon, a Nala flows adjacent to the crusher, the water of which is not used for drinking purpose.
So they have not said that this is a refuge.
Now, my lord, if C is supposed to with the explanation given in the same clause, there is an explanation with regard to the water body, my lord. The same
That
clause.
is any this creek,
So,
this
my
Nala.
lord, it says IC's RZ shall apply to the land area between SDL to 100 meter or width of the
No,
creek.
Mr.
whichever is-
Mr. Kumar, we are telling you this because there may be nalas which draw water from the sea. I mean, these falls under 2, but which areas are not within 500 meters of the tide line. Suppose beyond 500 meters from the high tide line, HTL. But even if it's close to 100 meter to the nala, then it will be governed by this ICRD. 2 operates independently from 1. If 1 operates by itself on its own strength, then 2 is not required to be seen. I mean, in the sense, both are applicable. If you come within 500 meter from HTL, then in any event you are governed by 1. 2 does not come into play at all. But if it's 500 meter away from the HTL, but still you are within 100 meter of the creek, then only this 2 comes into play. So it does not say that 2 does not say that the one with it's in exclusion of 1.
So, my lord, if my
Either
case-
of the 2 is satisfied by you.
Yes.
If it's a creek which is 500 meter away from the HTL, but still you are within 100 meter, it also applies there.
Yes. If it is
But
more
you-
than 100, then
Suppose it's more than 100 meter, but it's 500 meter from the HTL, then 1 governs you.
But
One
if
independently governs you.
that- my lord, if that is, my lord, there was no requirement for two. My lord, one thing can be done, my lord, because these facts, my lord, I want to bring on record, my lord. Let them file an appeal to that.
No.
Because, my lord, if my lord sees, because, my lord, so far as
No, it's a question of interpretation of this
yes, no,
regulation.
my lord, may kindly see this part.
For this
Distance
method,
from water body. This was there is a specific query in page number 40, which clearly asks distance from water body.
no,
Well,
we'll just say that they'll ascertain whether you fall within 100 meters of
More than 100.
more than 100 meters.
Yes.
No,
That has
fall
to-
within 100 meters of HTL from a nala
Yes.
or
Well,
1. Any of the provisions of this.
Yes.
Independently, if you
Yes,
fall
my
under
lord,
any of
it
these.
can- it comes, my lord, if it is suppose I am covered under 2, then definitely ICRZ is
No,
not.
is there any averment in the regulation that
No,
you
my
have-
lord, because this has been foreign one after another, my
No,
lord.
no. I am asking you, is there any averment that you are 500 meter away from the,
Yes, my lord, that is the pleading, my lord, that.
you are 500 meter away from the
So,
HTL,
my lord, that we have said.
not the nala, the sea.
My lord, we have said that as per the report, my lord sees para 22. I have just narrated the report, what is being stated in the report at para 22, my lord. Para 23 also I have said, my lord. This was absolutely on the basis of the report. I have not made anything. Para 21, my lord.
No, we can. I can just say that if it falls within any of the clauses of Roman 3, then it will be required. But that will be considered by them. But in any event, unless you make an application, there is no question. If you want me to, the court to decide that, and then I can decide here and now that whether it falls within ICRZ or not, which will go against you. Or I can direct you to give you liberty to file an application before the ICRZ, the authorities. They'll also consider the question of applicability. I can keep that open. That will be better
My
for
lord,
you.
application regarding applicability, I will give first, my lord.
No,
My lord, if I apply, then it is altogether different game, my lord.
then you submit to the
It's
jurisdiction.
all the documents, then I am submitting myself to the jurisdiction. My lord, that can be done, my lord. If my lord, they comes with the.
There is no scope of their adjudicating on the jurisdiction point cannot be assessed. This I can say that you will apply for this ICRZ, but that will not prejudice your rights and contentions regarding the applicability of the ICRZ. They'll consider that question as well as whether you come on.
For the purpose of applying, there are separate modalities.
Mr. Kumar,
My lord, if my lord asks them to, I will file a relevant application regarding whether it is applicable or not. Once they come with the clear finding that it is applicable, my
No,
lord,
there is a scope of adjudication by them at any
No,
prior
my lord,
stage.
regarding
Either you
the
apply,
application,
they can only, this authority can only decide on an application if an application is filed. Their jurisdiction is derived from your application. So we cannot direct them to decide the question of
but the
maintenance.
requirement, my lord, if I submit them and the requirement cost me more than 40 lakh rupees.
To apply.
Yes. Two reports are required. My lord, first report is
Yeah,
required.
is it your contention that you are 500 meters away from the HTL from the seafront?
No, I say, my lord.
Now,
that
do you
the-
say that? I take instruction.
No.
Are you 500 meters away from the seafront? If you say that, I'll direct affidavit for the supplementary affidavit, so that it can go before another.
That cannot be admit that you. No, we are not within, away 500. We say, my lord.
You are within 500.
Within 500.
Then you are.
But my lord, I say, my lord, see, what I am saying, my lord, if it is within 500 also, my lord, if clause 2 is taken independently.
I'll take the, decide that point right now against you.
My lord, because of
You have to apply. But this is regarding the environment. We cannot be lenient on these. Other things we can appreciate here.
No, my lord.
Concussion you will earn, commercially you will exploit. So not that we will be lenient to you or
No, my lord.
will be more lenient to the public at large who will be affected by
My
environment.
contention is that, my lord, page 40 and 41.
State is not always the villain.
No.
Sometimes it's the villain. Not always.
My lord, my argument is
Yes.
page 40 and 41. My lord, can you consider clause 9 and thereafter the page 41, which my learned friend also relied. I say that if it is more than 100, then this clause of
It says 165 meters away from the high tide line.
yes,
So as per page 41, if you go by this, it's required because my view is that A1 is applicable to you.
but I say, my lord, A2, if A2 comes into play, then A1 will not, because, my lord, it starts with.
This is circular argument.
No, no.
I have already expressed my mind.
My lord,
Yes.
NCR that shall apply to the land. I am on that.
It does not say ICRG shall not apply in other cases.
So, my lord.
It's not a negative cover, negative clause.
But if it is confined to, my lord, then in that case, for that purpose only clause 9 come into.
I'll
play.
interpret that against. Sorry. Learned counsel for the petitioner places reliance on annexure P9 at page 40 of the writ petition to argue that even as per the relevant authority, comma, the distance of the water body, the distance of the location where the stone crusher unit is sought to be set up by the petitioner is more than 200 meters from potable source of water. Within bracket, however, comma, during monsoon, comma, a nalla, NALLAH, flows adjacent to the crusher, comma, the water of which is not used for drinking purpose. Bracket closed. Sir, learned counsel submits, comma, by placing reliance on clause Roman 3 of the IPZ notification dated January 6, 2011, that under subclause Roman 2, small Roman 2, within bracket, comma, the ICRZ shall apply to the land area between HTL, TO2, 100 meters or width of the creek, whichever is less, on the landward side, along the tidal influenced water bodies that are up to which development along such tidal influenced water bodies is to be regulated shall be governed by the distance up to which the tidal effects are experienced, comma, which shall be determined in terms of the said clause. So next para, thus, comma, it is submitted that the stone crusher unit sought to be set up by the petitioner, comma, being beyond 100 meters as stipulated in clause capital Roman 3, capital A, within bracket small Roman 2, comma, the ICRZ notification does not apply at all. So next para, per contra, comma, learned counsel appearing for the respondent authority submits that subclause small I within bracket of clause capital Roman 3, capital A of the IPRZ notification, comma, 2011 stipulates the land area from a high tide land within bracket HTL, bracket close, to be 500 meters on the landward side along the seafront for the said notification to be applicable. Which of it is argued that the said clause applies independently of subclause small ii within bracket and such clearance clearance from the IPRZ authority is required. Which of next para, the relevant clauses are mentioned herein below. Page 3 of this I'm marking.
Yes. Yes.
Are mentioned, are set out herein below. 1 and 2 is Roman 1 and 2.
That's. Yes.
Goes to the next paragraph. From subclause small ii within bracket, it is evident that the same independently speaks about the applicability of the ICRZ to land areas between HTL to 100 meters or width of the creek in respect of tidal influenced water bodies, such as a nala. Full stop. Next para. However, a composite reading of the two provisions clearly indicates that subclause small I within bracket and subclause small ii within bracket operate on independent footing. Full stop. Notably, subclause small ii within bracket is not couched in a negative language, excluding the applicability of the other clauses of the notification. Full stop. Next para. For example, if a stone crusher unit is sought to be set up in an area which is beyond 500 meters from the high tide line on the landward side along the sea front, but yet, it comes within 100 meters between HTL from the HTL in respect of a tidal influenced water body, subclause small ii shall be applicable, although subclause small I within bracket will not be. Full stop. Next para. However, as in the case of the petitioner, if the stone crusher unit is sought to be set up in a location which is beyond 100 meters from HTL with regard to a tidal influenced water body, but still comes within 500 meters from the HTL on the landward side along this main sea front, the ICRZ regulation notification shall be squarely applicable to the same. So next para is such view of the matter, the argument of the petitioner as to exclusion from the IPRZ regime is not tenable in the eye of law on a plain interpretation of the relevant clauses of the 2011 notification. Accordingly, WPA 153 of 2026 is dismissed on contest without any orders to costs, granting liberty to the petitioner to apply before the appropriate authority from clearance under the IPZ notification dated January 6, 2011. If such an application is made and due formalities in that regard are duly complied with, the respondent authorities shall the appropriate authority shall dispose of the same as expeditiously as possible. No orders to cost service.
There are 6 of
The matter about Mr. Kumar. No, what is the nature of yes? What is the nature of just remind us once?
Let's be caught under the police station. To be as a Bangladeshi. Then when he has submitted out his offers, after 2 days, he has been from the police station. But 2 days later, he has been tortured at the police station.
So this
allegation before the authorities. So
FIR was not being registered.
he agreed by
You know, since you were there,
Yeah.
a Passover matter we can follow.
Yes, sir.
Ms. Elangu was there, yes.
Co-accused was already granted bail by the Supreme Court.
Give your half a second for the file, yes. Now,
The co-accused has already been granted bail. This is the order. Noting that they were behind the judicial custody for almost around 400 days. Out of 94 witnesses, only one was examined, and there were 14 more witnesses in the supplementary charge sheet. And he was directed not to enter into the vicinity of Northern Middle East. Same. My accused already.
Ms. Zinu, have you got a copy of that order? We just.
I'm giving.
Today is a bad day for Ms. Zinu because she's having to prepare herself on the go.
It's the same, but it's the co-accused, not a new ground, because
No, that we appreciate.
Karnataka has already gone through the case diary.
Yeah, that is a difficulty.
Fine.
Ms. Zinu has not gone through. So let her go through this order. $84 witnesses plus 14 witnesses.
Yes, ma'am.
So how many have been examined?
Only one.
One has been examined. That have gone up the ground and several that been shown.
Prime accused has already.
Yes, that is noted.
My concern may not be recorded, but that's not I need of this order.
Your objection may be. Learned counsel for the petitioner points out that the prime accused in the alleged offence against the petitioner has met his demise. Next para, one of the other co-accused persons was enlarged on bail by this court with a order dated April 23, 2026, passed in CRN within bracket M/3/2026, inter alia on the ground that out of the 84 witnesses mentioned in the charge sheet and 14 in the supplementary charge sheet, only one witness has been examined till date, and for the last 7 months, due to various reasons, not even a single prosecution witness could be examined in the trial. Hence, the conclusion of the trial is not in sight. In sight is aged. Next para. Although the nature of the offence appears to be grave, keeping in view the principles laid down in Dr. Rajinder Rajan, reported at Rajinder Rajan versus Union of India and another within bracket SLP within bracket CRL number 3326 of 2026, and in Mihir Rajesh Saha versus State of Maharashtra and another, reported at 2026 1 SCC 500, It is also to be noted that the constitutional mandate of informing the petitioner the grounds of the arrest also vitiates the arrest and subsequent remand and renders the same illegal, entitling the petitioner to be set at liberty, to be set free. Next para. On the above grounds, as well as on the ground of parity, since a co-accused person standing on similar footing has already been granted bail, CRM within bracket M/5 of 2026 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes bond of ₹10,000 with 2 sureties of like amount each, one of whom must be local, subject to the satisfaction of the learned Chief Judicial Magistrate, Mayabandar, and that the petitioner shall not leave the territorial jurisdiction of the South Andaman district throughout the period of trial without prior leave of the jurisdictional court. Even in any event, with or without such leave, the petitioner shall not enter into the territorial jurisdiction of the North and Middle Andaman district throughout the period of trial and or attempt to contact the witnesses or tamper with evidence in any manner whatsoever. The petitioner shall report to the Aberdeen police station every alternate day during the period of trial and shall make himself available, as and when required, for the purpose of recording his voice sample and taking his photograph, if not already done. Moreover, if so called upon to do by the trial court, the petitioner shall attend the trial comma, in which case, comma, during the short period when the petitioner shall attend such trial, comma, the petitioner shall report to the local police station closest to the trial court. Yes.
There is one ban also, I'm sorry, I forgot to mention that. And
Plan is for
leave to file the mail application and I think the photocopy of, because
before all this, just Grant 1 of 2026 is an application for leave to file the application without annexing the certified copy of the impugned order dated April 6, 2026. But isn't the certified copy already annexed?
yes, sir, I connect the photocopy. Certified copy was annexed along with the previous mail
In
application.
view of the urgency involved, comma, such leave is granted. Question of Grant 1 of 2026 is accordingly allowed. Question, the main bail application is now taken up for care. After that,
I'm grateful.
thank you, Mr. Yes. আচ্ছা একটা is allowed on contest.
Item 7, your partnership of primary session. Yeah, I am part of this.
Yes, Mr.
But this is the eighth, possibly 10th round. Three legal bench judgment is there, three division bench judgment is there. Thereafter, by suppressing all movable facts, same property, whose application expert stay was obtained.
You have given notice to the other side.
Yes, whereas you received the 11th council for the 20 proceed. I filed the available services. Now you will not appear, I know that.
Opposite party number 1 has received.
Only one.
Oh, there are no others.
Others are there, but they are performer.
Why are they parties, the others? And what is the context? Please just explain to us.
But
Just I
my
forgot.
survey number is 34 1 by 40.
Yes.
The land of the plaintiff is 34 1 by 15. He encroached my property, constructed a house, 34 1 by 14 here. Constructed a house. I approached the Tahsildar for eviction under the land revenue regulation.
Oh,
Tahsildar passed an order for eviction of the plaintiff. But he was not evicted. In the year 2016, I approached the honorable single bench. That order is appearing at page 61. This honorable court, single bench directed for eviction of the plaintiff from the said property. That order was challenged by the wife of the plaintiff before the honorable division bench. Division bench directed the Tahsildar just to give an opportunity of hearing, thereafter execute the order. Order was executed, possession was handed over to me. For treatment, I went to mainland, again he re-encroached the property.
that is a fresh cause of action, Mr. President.
But time, allow me to complete. He re-encroached my property, he filed a suit
Oh,
before the learned court bill. I contested the suit, ultimately the suit was dismissed. Again he filed appeal before the learned district judge. Appeal was also dismissed. He filed a second appeal. Second appeal was also dismissed. I filed one writ petition for implementation of the order passed by the Tahsildar. The honorable single judge directed for implementation of that. Against that order,
implementation had already happened.
now again Tahsildar passed one order, 22nd April 25.
After the second appeal was dismissed,
Yes,
Tahsildar passed another order.
yes,
22nd of
April 2025. That order was again challenged by again filing a writ petition, 226. That was also dismissed. Against that dismissal order, again appeal was filed before the honorable division bench, MAT 31 of 25. That was also dismissed. At the time of dismissing the appeal by the division bench, directed the Tahsildar to execute that order. That was not executed. I filed a contempt application. That contempt application is pending. During pendency of the contempt application, the plaintiff again filed one suit challenging the subdivision order passed by the Tahsildar 15 years. This deputy commissioner 15 years ago. The ex parte interim was added injunction was granted. Thereafter, I entered appearance. I filed my objection. I contested the injunction application. At the time of hearing, the learned civil judge senior division said in open court that suit is not maintainable. I am going to frame a preliminary issue. It was fixed for orders after 20 days. After 20 days, status quo order was granted. That status quo order I challenged before Learned district judge by filing misappeal. Pray for stay of the order. The stay was refused. I am before your lordship. For the last 10 years, my client is 66 years, 67-year-old.
Let us once see the impugned order.
My lord.
The present impugned. What was the stay granted of that 15-year-old order of the Tehsildar? What stay was granted?
Status quo to
No, stay has been granted. Here it says stay.
Status quo.
Where is the their application prior annexed here?
Yes.
This was that on the basis of which this order was passed. But the court says ad interim relief of stay as sought for in the application is ad interim relief of stay. Oh, your stay is refused, right? Sorry.
This is,
Yes, right.
This is page 37.
Right. Well, since they're not appearing, we're disposing of. Despite service.
She is appealing.
Yes. Respond number?
1.
He may be out of station, you are not. Respond number 1 has been appearing personally.
No.
Council is out of session.
Who is the counsel?
Okay.
I saw
Nothing.
it, my lord.
Sorry. When the matter is called on for hearing, despite service, at the time of call, an adjournment is sought on behalf of the opposite party number 1. Whose next para. However, due to the gross injustice being meted out, METED, to the petitioners, the matter is taken up for hearing. Whose next para. The brief backdrop of the case is as follows: the defendants stroke petitioners are the owners of survey plot number 34 by 1 by 14, whereas the plaintiff stroke opposite party number 1 owns survey plot number 34 by 1 by 15. First up, in view of the plaintiff stroke opposite party number 1 having encroached upon the petitioners property, an application was moved before the Tehsildar, who passed an eviction order against the plaintiff stroke opposite party number 1. First up, the matter came up before a learned single judge of this court, who also directed eviction. First up, thereafter, an appeal was preferred by the plaintiff stroke opposite party number 1 before the concerned division bench, wherein, although not interfering on merits with the eviction order passed by the learned single judge, the division bench directed the Tehsildar to give an opportunity of hearing to the plaintiff stroke opposite party number 1. First up, such opportunity was given, and thereafter the order of the Tehsildar was duly executed. First up, next para. However, the woes, woes of the petitioners started thereafter. First up, the plaintiff stroke opposite party number 1 encroached upon the survey plot number 34 stroke 1 stroke 14, belonging to the defendant stroke petitioners. First up, next para. Not stopping there, the plaintiff stroke opposite party number 1 filed a suit which was dismissed on contest, leading to an appeal being preferred by the opposite party number 1, which was also dismissed. First up, a second appeal preferred by the opposite party number 1 against the same met MET with the same fate, FATE.
Page 107, you will see one paragraph, just one paragraph. That is required in another matter also. 107. Second paragraph.
We're not entering into it. So we have already held that it. As a very we will record a like this. While dismissing the appeal at the stage of hearing under Order 41 Rule 11 of the Code of Civil Procedure, the division bench observed, inter alia, that both the trial court and the appellate court, on examination of the documents and evidences, have had come to a definite finding that survey number 34/1/15 is under occupation of one Matthew Joseph. Matthew Joseph is the opposite party number 1.
No, he is not there in the picture.
Joseph, full stop. It was further observed that the said finding is based on material including affirmation of possession of Matthew Joseph in earlier proceeding between the parties. Full stop. Next para. Be that as it may, after such dismissal, the Tahsildar vide order dated April 22, 2025, again directed eviction, upon which the petitioners filed an application for implementation of such order by re-evicting the plaintiff / opposite party number 1. Full stop. Next para. A writ petition under Article 226 of the Constitution of India, filed by the opposite party number 1 against the said order of the Tahsildar, was dismissed. Full stop. A mandamus appeal preferred against the same was also dismissed, the division bench directing execution of the order of the Tahsildar.
122 page number 1.
Full stop. Next para. Mr. Prashant, we believe counsel. Next para. Thereafter, since the order was not being implemented, a contempt application was filed. Full stop. Next para. However, the plaintiff / opposite party number 1 filed another suit challenging the order of the deputy commissioner, which was passed 15 years ago. Full stop. In such suit, an ex parte ad interim status quo order was passed, which was challenged by the present petitioners before the.
No. Ex parte order was passed. Thereafter, he entered appearance. I filed my objection. On contest, it was allowed.
Full stop. Ex parte ad interim injunction status quo was granted. Full stop. Thereafter, the present petitioners entered appearance and contested the interim application. Full stop. Ultimately, on contest, the temporary injunction application was allowed, granting status quo in favor of the plaintiff / opposite party number 1. Full stop. Next para. Challenging the same, an appeal was preferred. Full stop. The appellate court was the district judge,
Yes.
the present appeal.
Yes.
Full stop. The learned counsel for the petitioner alleges that the matter was reserved for orders, and the learned district judge was initially of the prima facie opinion that.
No. The trial court.
Then we are not going into that. Send a second. Next para. By the impugned order dated April 6, 2022, passed in the appeal preferred by the present petitioners against the order of status quo, the learned district judge refused ad interim stay on the, thereby turning down the prayer of the appellants / petitioners for stay of the impugned order of status quo. Full stop. Next para. Assailing the same, the present revision has been preferred. Full stop. From the annexures to the present application, as well as the arguments of counsel, it is evident that the plaintiff / opposite party number 1 has been repeatedly thwarting the efforts of the petitioners to get their legitimate rights, despite such right having been vindicated on several occasions before several fora, FORA. Full stop. Next para. That apart, the suit was not even prima facie maintainable, comma, being barred by limitation, comma, since an order passed about 15 years ago was sought to be challenged therein. Full stop. Next para, thus, comma, this court is of the opinion.
Adjudicator is also there.
Full stop. Next para, that apart, comma, as rightly argued by learned counsel for the petitioners, comma, the suit is also barred by res judicata. Full stop. Next para, in such view of the matter, comma, this is one of the exceptional circumstances when at the ad interim stage in a miscellaneous appeal filed against the status quo order itself, comma, an order of stay of operation of the impugned order of status quo ought to have been granted, comma, although under normal circumstances, comma, such stay orders are not granted at the premature stage of admission of the appeal. Full stop. Next para, in view of the above observations, comma, this court is of the firm opinion that the learned district judge erred in law as well as on facts in refusing to grant stay of operation of the order of status quo dated March 17, 2026, passed by the learned civil judge, comma, senior division at Port Blair. What is the suit number?
Title suit number 133 of 2021.
In title suit number 133 of 2025. Full stop. Next para. Accordingly, CO number 26 of 2026 is allowed, comma, thereby setting aside the impugned order bearing order number 2 dated April 6, 2022, passed by the learned district judge within bracket in charge bracket closed in miscellaneous appeal number 05 of 2026 and granting stay of operation of the order dated March 17, 2026, passed by the learned civil judge, comma, senior division at Port Blair in title suit number 133 of 2025 till disposal of the said appeal. Full stop. No orders to cost, urgent certificate. Yes. You and three, take it. Thank you. 2 and 3 but not for 1. State. Oh, this is a matter about. Please use the microphone, ma'am. Yes.
Here I am paying the integrity.
Yes.
That's my number 2, 3, and 4. Here, the
2,
learner,
3, and 4 are not 2, 3. Your yes.
here the learner could pass an order.
Like
Here the learner for below has passed an order for confiscation of the seized article. Confiscation of the seized article by the state. That is the forest department. But I am the necessary party because I am doing a bank. This seized vehicle, here seized articles are seized vehicle is also included. Sawn timber that is Padapur has been transferred by the accused person from within state to Port Blair. At the time, this article sawn Padak has been seized at the city card by the police officer, and they have intimated to the forest department. The forest department has seized the article. Thereafter, intimation complaint has been filed for the magistrate to take the cognizance. Magistrate has taken the cognizance. The accused person has filed an application taking the date, and by pleading guilty, the order has been passed by the learned court below, confiscated of the seized article to the state. But due process of law has not been followed. I have not been given an opportunity to file my application stating that my vehicle, which has been confiscated, it has been hypothecated to the bank, and because the loan has not been
But your
paid by the original.
Your civil rights operate in a different regime of law.
But the forest.
Whatever has been in accordance with law, he has pled guilty, and this has to be confiscated. Your rights, you are entitled to ventilate in a proper civil forum.
It also is also pending.
What should money suit is?
My city is
Then your rights should be ventilated.
I Because as per section 54, 56 and 57 of Indian Forest Act,
Forest Act.
that it is very much clear that due process of law is required to be followed. And owner is required to be given a chance
You
so
can-
that I may file an application and I may be given a chance so that if lower court
You are
says that I am not
the
considered
bank
to
is
be
the
my
owner of that vehicle.
destination.
Hypothecation. It is hypothecated to you.
I know.
Honor will do. You may honor me. Yes.
Well, because payment has not been cleared by the original owner. So the liability remains upon me also, because this is the public money.
Show us the sections. Show us the sections.
Section 54, 56 and 57. For section 54 of
54 is general.
Indian Forest Act. On the receipt of any such report, the magistrate shall, with all convenient dispatch, take such measures as may be necessary for the arrest and trial of the offender and disposal of the property according to law.
None of these sections help you. I've seen all the three sections. Which one helps you? Which one requires an?
After confiscation.
You are first of all not the ma'am. You are first of all not the. You are not the owner of it.
Madam, owner is defined in motor vehicle.
It's hypothecated to the
Yes.
that person.
Yes. And
Hypothecation, yes. Yes.
MDI. Owner defines,
Right.
owner means a person in whose name a motor vehicle stands registered. And
Yes,
where such
probably you have a
person-
point there, because the concept of hypothecation is he does not become an owner unless the entire loan is.
And so- Yeah,
But this act, Forest Act, the provisions do not
why not? At least
contemplate any hearing of the owner.
provision.
But
This 56 may be seen by law. After confiscated, at least court's permission is required to dispose of the vehicle. Next step, but before that, I want entry in this regard, because if they
any particular section which
for the RTO for transfer of the ownership, and they have
yes.
it has been informed by the RTO department.
No. The ownership he has repaid the entire loan amount.
No, that is the issue. I have made my
You
objection.
said you civil rights.
My lord, here, my lord, kindly 56.
56 years.
When the trial of any forest offence is concluded, any forest produced in respect of which such offence has been committed shall, if it is the property of government or has been confiscated, be taken charge of by forest officer, and in any other case may be disposed of in such manner as the court may direct. They have not taken any direction from the court to transfer the ownership. They have, as per the order of the London trial court, this article has been confiscated.
This vehicle stands in your name,
By
in the bank's name.
no, original owners.
Respondent number
But
5.
I am the,
Respondent number 5.
You have a right. You have a
and the owner may be a definition of
see the definition of the owner. Read it.
MBF
Yes. 230. 2 within bracket 30.
means a person in whose name in motor vehicle stands registered, and where such person is a minor, the guardian of such minor, and in relation to a motor vehicle which is subject of a hire purchase agreement or an agreement of lease or an agreement of hypothecation, the person in possession of the vehicle under that agreement.
Your answer is there. Your answer is in this section itself. Read the last portion again. Where it's under hypothecation, the person in possession of the vehicle under the agreement.
Minor,
Why did you mention this matter before this court on an urgent basis?
this stays
Bad code, bad order, it will be dismissed.
minor.
Bank
Because
doesn't
I,
have. In that proceeding, but I'll obviously needless to say, but when we say needless to say, still you say it. We'll say needless to say the bank has its has a right to yes, recover the loan. Not only that, ventilate all civil rights before an appropriate forum or court. That is the reason. This last submission is the reason for which one of the judges of the Allahabad High Court is now no longer precluded from taking up criminal matters throughout his life. This proposition. precisely this proposition. I don't want to follow that trade, although I'm not much interested in.
First, they will transfer the ownership. And here the public money is involved, my lord, what?
No, definitely, but this is not the process.
Or else, my lord, or
What?
that in civil, I will be given liberty for that, to the forest department, and till I am filing the application.
No liberty will be given from here. This is not not any proceeding arising from the civil suit. You are at liberty to do whatever you like. I'll not advise you, but you may have you're in good hands.
But
Your
once
client
it-
is in good hands, so you
once
advise.
it is transferred, it will be difficult for the bank.
No,
Because, and also they have.
then it
paid
will be a
only
question.
1 lakh,
Then
And here the loan amount is of 10
that is
lakh.
the precise concept of a secured credit. Who is a secured creditor? That will be seen first. Whether the state in this case or the bank, whoever is the secured creditor, you come within the definition of secured creditor, you take your dues from the state or whichever authority. But we won't go into that here.
Please.
I'll not touch that. I'll not dismiss that from here. But I'll merely say, what have you challenged here precisely? What is your prayer in this referral?
I have one more.
Final order passed by the honorable state of the court. Thereby, he has been pleaded guilty and imposed fine, and these articles have been prosecuted in terms of the order.
The confiscation.
They have agreed by the order passed with the commission revision.
Also, I have prayed if some liberty will be given to appear before the learned court and file one application
Which court? No.
for modification. Learned
No
court.
liberty will be given to you. If you have that liberty in law, exercise that. I
Because the act does not permit, no revision is there, no rule for revision is there.
You're
only
giving
appeal is there.
you're giving the answers to your questions in your own arguments. The act does not permit, why should I?
My lord, here for revision, I cannot go to,
No, you ventilate your civil grievances in a proper process.
Then
Either under a DRT.
ownership may not be transferred.
The bank stroke petitioners has challenged an order of confiscation of a vehicle involved in an offence under the Forest Act, 1927. So, learned counsel for the petitioners argues that the offending vehicle, in which the seized articles were found, belongs to the bank, since the same was under hypothecation to the accused person. Pushed up, next para, learned counsel further submits.
Is the respondent number 5 is the owner. This was no connection with that. So the owner is
Was hypothecated
by the respondent.
to the respondent number 5. Here. Push up next para. Learned counsel for the petitioner submits that within the contemplation of section 2 within bracket 30 of the Motor Vehicles Act 1988, double inverted owner includes a person who has given a property in hypothecation to another. So next para, learned counsel further argues that, as such, within the purview of sections 54, 56 and 57 of the Forest Act, 1927, the court, before passing an order of seizure, ought to have granted an opportunity of hearing to the bank, under which the vehicle in question was confiscated, was hypothecated. So next para, learned counsel appearing for the respondent numbers 2 and 3 opposes the prayer and submits that a criminal revision is not maintainable in these circumstances. So that apart, it is also disputed that the bank was the owner of the vehicle in question. Next para, from the materials before us and the law governing the subject, the court is before us, before the court, the court is unable to agree to the submissions of the petitioners. Next para, section 2 within bracket 30 of the Motor Vehicles Act, 1988 reads as follows. Just quote it.
No.
Next para, from a bare perusal of the same, it transpires that the entity which has hypothecated a vehicle does not come within the purview of owner. Push-up in respect of hypothecated articles, comma, the person in possession of the vehicle under the hypothecation agreement has been included within the purview of owner under section 2 within bracket 30. Push-up. Thus, comma, the argument of the petitioners on such count cannot be accepted. Push-up. Next para. Even under sections 54, 56 and 57 of the Forest Act 1927, there is no mandate on the court, before directing seizure, to give notice to an entity or a secured creditor which has hypothecated a vehicle to the offender or the owner of the vehicle. Next para, in any event, in the present case, the vehicle stands registered in the name of respondent number 5, and as such, even under the Motor Vehicles Act 1988, the petitioners cannot claim ownership of the property. Next para, that apart, since the accused person himself pled PLED guilty of the alleged offence, the concerned magistrate, the learned chief judicial magistrate, Andaman and Nicobar Islands at Port Blair was fully justified in passing an order of confiscation. Thus, there is no scope of release of the vehicle to the petitioners within the regime contemplated under the Forest Act 1927 and or any other statute, for that matter. Next para. Accordingly, CRR 27 of 2026 is dismissed, thereby affirming the impugned order dated October 10, 2025, passed by the learned chief judicial magistrate within bracket A and N Islands, bracket closed, at Port Blair in CR number 99 of 2025. Next para. However, it is made clear that nothing in the above order or the order impugned herein shall prevent the petitioners from ventilating their grievances with regard to the hypothecated vehicle before an appropriate civil forum court, if not already done.
Okay.
If not already.
I thought it's where other steps.
Yes, yes.
Blair.
What is the
That's your conscientious matter to say, I'm for the petition, very short, page 56, maybe. Page 56, para 6 is the issue.
refused? Why refused? Let us see the reason.
That matter, kindly come to page 34. The appellate court, my lord, the opposite party relinquished his share in my favor. Page 34, order portion will be seen. His share is to be added in my favor.
On consent.
On consent. The learned trial court is directed to provide preliminary degree.
You are Basantila.
Basantila.
Right.
And at the relevant point of time, my name is Basanti Kumari.
The opposite party is Sangamla.
Sangamala. No, with regard to the merits of the case, no dispute.
No, consent, yes.
Yes, 39 may be seen here, page 39. I filed, not me, the plaintiff filed application under order 6 Rule 17 that was allowed by the trial court. 39.
That was the same error.
Same,
That has been corrected by the trial.
corrected by the trial court. Now the matter is, the appeal was, appellate court passed this order, page 34.
No, the appeal has been preferred by Sangamla.
Sangam. No, me. Appeal was prepared by me, Basanti Kumari,
Against what?
against the judgment.
It's a consent decree.
Well, trial court passed a degree in favor of Sangaramlal,
Preliminary decree.
preliminary degree.
Oh, you have
filed
challenged the
appeal.
final decree. No,
Yeah,
that-
preliminary degree.
That's a consent.
Yes, in page 34, consent order was passed.
Can you challenge the consent order?
I am not challenging. I am not at all challenging because it was in my favor.
So why do you prefer the appeal against what?
I prefer to appeal against the preliminary degree.
Against the final degree.
Well,
This
No.
is the preliminary degree. Page 34 is the preliminary degree.
no, this page.
Oh, the appellate court directed the trial court to draw up a preliminary degree.
Preliminary degree.
So preliminary degree was drawn up in terms of this.
It was not drawn up. Because the mistake is there, Basanti Lal and Basanti Kumari.
Oh,
Application was filed, that was allowed.
oh, trial court allowed that.
Trial court allowed. Now appellate court is not allowing. This is the short issue.
Why not allowed? Let us see.
Not on merits. My learned junior committed a mistake.
Yes, this is a cognizable mistake. Cognizable of this. Yes, what do you say?
I have no objection. Lord.
Very good. The scope of the present revisional application is short. First, sir, in a partition suit between the parties, comma, the preliminary decree was taken up to appeal. First, up the learned district judge, comma, while disposing of the said appeal, comma, recorded that the judgment and decree passed by the learned trial judge was affirmed and partially modified to the extent that the share of respondent number 1 within bracket present opposite party bracket closed would be added into the share of appellant Basanti Kumari within bracket present petition number 1 bracket closed. The learned trial court was directed to draw a preliminary decree in terms of the prayer made by the parties. Full stop. Next para. Such judgment was passed in terms of the concession given on behalf of the opposite party. Full stop. Next para. Subsequently, comma, it was detected that the name of what is the actual name? Basanti Lal.
Basanti Kumari earlier, after marriage, she was known as Basanti Lal.
Was so what the correction sought is Basanti Kumari.
Basanti Lal.
Lal. Instead of Basanti Lal, Srimati Basanti Lal, LALL, comma, the name Basanti Kumari, comma, as reflected in the records of the trial court, were directed to be rectified in terms of the amendment prayer made by the petitioners. Next para. However, comma, when the self-same prayer was made before the appellate court, comma, the learned district judge, comma, by the impugned order, refused to grant such prayer, apparently on the ground that from the case record, it appears that the name of the appellant has been mentioned in the cause title as well as in other documents as Basanti Kumari, and nowhere it has been filed that the said Basanti Kumari is also known as Basanti Lal. Pushed up. Next para. Learned counsel appealing for the opposite party submits on instruction that the opposite party has no objection to the correction being effective. Pushed up. Next para. In any event, comma, since the court is apprised that Srimati Basanti Kumari and Srimati Basanti Lal is the self-same person, comma, the change of title having occurred due to marriage, comma, and as a similar prayer has already been allowed by the trial court, comma, the court finds no impediment in allowing such correction. Full stop. Next para. Accordingly, comma, the impugned order cannot be sustained. Full stop. CO 28 of 2026 is allowed on consent, should we say? Allowed on consent, comma, thereby setting aside order number 36 dated March 9, 2026, passed by the learned district judge, comma, Andaman and Nicobar Islands in title appeal number 12 of 2018, and directing the granting leave to the and directing the records of the appeal to be corrected by the concerned department of the district court to the effect that the name within double inverted Basanti Lal, double inverted close, of the appellant may be rectified to within, sorry, Basanti Kumari. The name Basanti Kumari should be rectified to within double inverted Basanti Lal. Such corrections shall be carried out as expeditiously as possible, comma, positively within a fortnight, a working fortnight from the date of communication of this order to the district. No orders to us, Arjun Secretary. Working fortnight, Stephen. Big question.
Then you are talking about 126.
Lordship, I have for the petition. Lordship,
What about the other side? Ms. Lal?
other side, Lordship, I will explain. I have served the council. The affidavit of service is there. The person that is the opposite party is also the opposite party in Mr. Arun's case. He has read Arun. He has gone to mailing after the election has taken place. So it is not possible for me to serve him. But the council who is appearing for him, he has already.
Appearing in the trial court.
Right.
You are appearing for. Oh, how can you appear? Yes.
So he has already been.
It will be a case of domestic violence. Yes.
Already served in Lordship. Lordship, here the case is that an eviction order was passed by the Tehsil. Now, Your Lordship, I came to know, my client came to know that the connivance with the private respondent.
No, you are the other side in Mr. Prasant's matter.
No, I'm not the other side.
So
That particular other side.
then orders will be contradicted. Oh, you are Matthew Joseph, whose name was recorded.
Yes.
That's why Mr. Prasant was helping you out by saying it will be relevant in another case.
That same person is claiming his land also my land.
So what is the impugn order?
Now, yes, what happened? This is the passing eviction against me. Now, I have instituted a suit in respect to the state property by filing a civil suit, and I paid for an injunction order. Court has granted me an injunction order.
That is 34 by 1 by 15.
Yes,
Your land.
the land is 34/1. My land is 34/1. Now,
One covers 15 also. It's a subdivision.
it's a huge chunk of land. Some portion of land has been sold to many persons. One of that particular person is Shakti. It is not that he is not the owner of 34/1 of 15. He is. But his location is problematic. He is not able to identify
You
his
sought
own
for a
land.
local inspection.
Yes,
Refused.
allowed.
Then?
The problem is that, Your Lordship, when it was allowed, there was some problems with regard to appointment of commissioner that the person is concerned. The commissioner was, I said, Your Lordship, I have submitted to the Honorable Court, there is a problem with that commission. The Honorable Court changed the commissioner, and that commissioner refused. And after that, the problem is that the learned trial court, without considering the entire material where I have alleged against the Tehsildar itself, the Tehsildar is the person who has done all these things, and I have mentioned in the entire suit. Learned trial court appointed Tehsildar as a commissioner. What relief I get? His eviction only, Your Lordship, is the dispute, and the entire thing I have done against the Tehsildar only. And I have said it, he is acting in connivance with the Tehsildar.
Your prayer was to appoint an advocate commissioner.
Yes. Only an inspection that actually eviction took place. I'll just read Your Lordship, it's very small. What happened, Your Lordship? 11th April was the date fixed for eviction. I filed the suit, and on 10th April, I obtained an interim order.
11th April of which year, Ms. Nal?
This same. 10th April, I obtained an interim order from the learned trial. I requested the learned trial court that the order may be communicated to the Tehsildar. Learned trial court directed us to communicate the order to the Tehsildar. It was communicated, and the forwarding letter also is there in the lower court file. Despite such fact, on 11th April, he demolished, cut down the entire trees, he demolished the boundary wall with Hitachi and everything, and handed over the possession to the respondent number. I filed an application for inspection. I filed a contempt application for reference under section 10, and then I also filed an application for inspection. And what was the inspection? How many trees have been cut down? Counting of the trees. What is the position of the present structure? Only inspection, not investigation at all. So this application was allowed. The problem is that it's learned trial court.
Got your point of analysis. Despite service, none appears for the opposite party. Full stop. Next paragraph. Learned counsel for the petitioner submits that the petitioner is the owner of survey plot number 34/1. Full stop. However, at the instance of the opposite party number 1, only opposite party number 1, the
Yes, Your Lordship.
opposite party number 1, an eviction order was passed by the Tehsildar. Full stop. The petitioner, being aggrieved, filed a civil suit before the competent court. Full stop. In the said suit, an interim order of protection was passed on April 10, 2026, whereas the date fixed for implementation of the eviction order by the Tehsildar was the very next date, that is April 11, 2026. So next para, it is argued that despite communication of the order of the learned trial judge in the civil suit to the Tehsildar, the Tehsildar went ahead with demolition of a portion of the boundary wall as well as felling trees on the property allegedly belonging to the present petition. Which the next para, in the teeth of such allegations, a contempt application was filed. In connection with the contempt application, the petitioner also made an application for local inspection by appointing an advocate commissioner, before the civil court. Which the next para, the initial appointee. Since the petitioner had certain issues regarding the initial appointment, at the behest of the petitioner, the first advocate commissioner who was appointed was changed. However, the second advocate commissioner, what happened?
She refused.
However, the second advocate commissioner who was approached refused to conduct the inspection work. Next para, by the impugned order, the learned trial court within bracket, the trial court appointed the very same Tehsildar as commissioner, instead of an advocate, to hold the local inspection over the suit property. Next para, the council argues that appointment of the Tehsildar is contrary to basic tenets of natural justice and principles of law, since it is the very Tehsildar it is the very person against whom allegations have been made in the contempt application, in connection with which the local inspection application was filed. Next para, the court finds substance in the contention of the petitioner, since it will be patently detrimental to all principles of natural justice to appoint the very person against whom an application for contempt has been filed, alleging willful disobedience of the order of the civil court, in connection with the contempt application itself. Next para, thus, the impugned order cannot be sustained. Accordingly, CO 31 of 2026 is allowed, thereby setting aside the impugned order, bearing order number 7 dated April 12, 2026, passed by the learned civil judge, senior division at Port Blair, in title suit number 45 of 2026, and directing the learned civil judge, senior division, to appoint an advocate from the local bar as the commissioner to carry out the local inspection already directed by the trial.
I have to go back only 2 days and then holidays, 30 days holidays, Your Lordship. The entire topography of the land will be changed. I pray Your Lordship may appoint it.
We don't know anything about the you will be competent.
We have juniors, Your Lordship. Any junior can, it's only inspection. They have to see that trees, how many trees have been cut. I have not asked a complicated question. Any junior can be.
You have already set up a junior.
No, Your Lordship, I have asked.
Very good.
Junior Ananda Biswas is there.
Yes, I've seen. Set aside, thereby directing portion. No. After set aside, it will be there. thereby setting aside the impugn order such and such, and directly that portion is go through. Instead of that, setting aside such and such full stop. Since the petitioner submits that the trial court is on the verge of closure for the upcoming summer vacation within 2 days, comma, it may not be possible for any learned advocate from the district bar to be appointed, comma, I hereby appoint Ms. Ananya Biswas, comma, a learned advocate practicing in this court, to as advocate commissioner for the purpose of carrying out the inspection as directed earlier in title suit number 45 of 2026. Full stop. The parties and all concerned, comma, including Ms. Biswas, comma, learned advocate, shall act on the server copy of this order without insisting upon prior production of a certified copy. Full stop. Learned counsel appearing for the petitioner, the learned advocates appearing for the petitioner are requested to cooperate with the advocate commissioner by furnishing copies of all relevant papers, comma, including the application for local inspection, as well as the order directing the order allowing such application, as well as a copy of the plaint of the suit at the earliest. Full stop. Such local inspection shall be completed as expeditiously as possible upon prior notice to both sides. Both sides. No response. What should be a problem? Ms. Ananya Biswas was the lady standing behind me. You are Ananya Biswas. You say that, tell me the remuneration.
10%. Clear lordship.
What is the make of car you ride, Ms. Nag? Your client may not write that. We agree with that. What does it do, this Mr. Matthew Joseph?
Pharmacist.
Pharmacist.
Pharmacist in there.
23rd. Advocate of this could be
Yes.
20th. The remuneration of the learned advocate commissioner appointed above is hereby fixed at ₹20,000 to be paid to her at the time of the inspection, at or before the time of the inspection. First up, next para. Leave is granted to the learned commissioner, learned advocate commissioner, to approach the local police station, comma, if any resistance is faced by her at the time of such inspection. First up, if such approach is made, comma, the officer in charge, station house officer, here it's called,
Yes.
the station house officer of the local police station having jurisdiction, and or, comma, if not available, comma, the next in charge of the said police station shall extend all possible police assistance to her for the purpose of completing the inspection work by acting on the server copy of this order, comma, also without insisting upon prior production of a certificate. Thanks. Yes.
Your Lordship, I have the exceptional, Your Lordship. This has got the same case, Your Lordship. I have challenged the order of the Tehsildar and I have asked for restoration. I think giving file opposition, let them file opposition. This will take time.
You do the matter for them also. You argue their case also. What is left? So you'll file opposition.
Yes.
I'll be happy to direct opposition.
Because I know, Your Lordship, ultimately after hearing the entire thing, Your Lordship will pass the order for
Yes,
opposition.
right now we know.
Be required.
No, you have served on the other opposite parties as well.
Yes.
The respondent.
Sir.
Despite service, comma, only the respondent numbers 1 and 2 are represented before this court, apart from the petitioner. So next para. On the pair of learned counsel appearing for the respondent numbers 1 and 2, comma, the respondents are directed to file their affidavits in opposition to the writ petition within what will be a reasonable time is thus 4. within 4 weeks from date, full stop, reply if any shall be filed within
1 week.
1 week thereafter, full
Next
stop,
certificate.
full stop, liberty to the parties to mention before the next available circuit for inclusion in the list after the above timeline for filing of affidavits is over. Thank you.
Obliged.
Item 12, wrongly appeared. Item 13, WPS.
Wrongly একটা order pass করতে হতে wrongly appeared কেন?
already passed.
আচ্ছা ঠিক আছে, not to record. No order.
Item 13, WPS.
And he's not necessarily present. He's out of station.
What is his name? Yes, what is 13 weeks for the petitioner? Oh, you are for the petitioner. So you are asking for 10, you are adjourning it. On the prayer of the petitioner, the matter is adjourned for the day and shall be listed in the next schedule. Acha, fair. Affidavits in opposition, if any, shall be filed by the respondents within a fortnight. Within a fortnight from date, full stop, reply thereto, comma, if any, shall be filed within a week there.
Item number 40,
14 or 23 action director. Yes, I'll just look into that previous order and it will be a copy paste. Basically. Yes, Mr. Rakesh Kumar, no objection to copy paste. Sector line article. Due to the identity of the issues involved, comma, the above matters are taken up together for hearing. After there will be a common first step. Full stop, next para. Learned counsel for the petitioners apprises the court that in another writ petition bearing WPA 158 of 2026, comma, arising out of an identical issue, comma, the court has directed affidavits to be filed. Full stop. Next para. Server copy of the said order is also handed over to us. Handed over to the court. Full stop. Next para. Accordingly, comma, in the light of the said order dated April 16, 2026, passed in WPA 158 of 2026, comma, the respondents are directed to file their affidavits in opposition to the writ petition. The affidavit in opposition to the writ petition within a fortnight from date. Full stop, reply thereto, comma, if any, shall be filed within a week thereafter. Full stop. The present writ petitions shall be tagged along with WPA 158 of 2026 for hearing. Full stop. Liberty to mention for enlistment before the next available circuit. Well,
item 24,
I'm
yes.
for this one. But I'm paying for directions from the respondents to dispose of my representation in the time of that.
When was it given?
It was filed 15th of March 2026. That is a page number.
Which respondent should be directed?
Page there.
Only this. What will be a reasonable time is thus? You are for the administration, you tell us. We will not do something which you can't complain.
So all the four tenants have to be given opportunity of hearing such a mutation matter. And what I was working with, like
2 months?
Tehsildar has done the mutation only in 1 week.
1 day?
Of 1 month time, I think. All other legal are there, but only the name of one legal it was.
2 months will suffice.
She wants to review the mutation order. And in case that does form.
No, review the mutation. No, so 2 months will be from date of communication, we'll say. Good. The innocuous prayer made in the writ petition is for an early disposal of the representation submitted by the petitioners to the respondent to Tehsildar on March 16, 2026 for review of the mutation order of land bearing survey number 24/P/A measuring about 500 square meter. So next para, upon hearing learned counsel for the parties, comma, WPA 256 of 2026 is disposed of by directing the Tehsildar, Sri Vijayapuram, Tehsil, South Andaman, within bracket, the respondent hearing, bracket closed, to consider and dispose of the representation dated March 16, 2026, filed by the petitioners as expeditiously as possible, preferably within 2 months from the date of communication to the respondent. Upon such disposal, a reasoned order shall be passed in writing, and the same shall be communicated to all the interested parties. Next para. Thank you. It is further clarified that prior to such disposal, the respondent shall give adequate opportunity of hearing to all interested parties. The respondent shall act on the communication of the learned advocates for the parties, coupled with a server copy of this order, without insisting upon prior production for the certified copy thereof for the purpose of compliance. No rest to cause certificate.
One. Items of ten. The learners constraints to direct is to submit the report on the job to the learned file. That is the main.
Title note says
But
the Tehsildar was directed to file on that date.
Because date was fixed. So I will say.
The reopening date is the date fixed.
No.
On the next date, she'll file.
That has to be mentioned.
The learned advocate commissioner shall file her report after completion of the commission work on the next before the trial court on the next date fixed in the suit.
Yes. Okay.
Oh, this is for a correction. Sorry. In our order dated April 21, 2026, the name of the learned single judge before whom the matter was directed to be placed was erroneously recorded. Accordingly, the said order be deemed to stand corrected by recording the name of the learned single judge as Raja Basu Choudhury, J. Let this order be deemed to be a part of the order dated April 21, 2026. Thank you.